Any mention?
May it please, Your Lordship. Your
Yes.
Lordship, I beg to mention item number 29.
29.
Yes, Your Lordship, I can pray for 2 weeks' time. 2 weeks' time, Your Lordship.
29. Yes.
They have informed me, yes, Your Lordship.
Yes.
I have not.
So you inform me, that means you have the ultimate authority to grant them injunction, adjournment. 2 weeks, okay, yes.
Obliged, Lordship.
May I please, Your Lordship, I beg
Yes.
to mention item number 35, Lordship.
30? 30?
35, Lord.
Lords, I have no objections.
2 weeks, okay.
Good evening,
Obliged,
Lordship.
Yes, Mr. Lalu.
Please, Lordship, I beg to mention item 32.
40?
32. The conducting senior counsel is not well, so I pray for 2 weeks.
2 weeks. As our counsel is not, is indisposed, still to be indisposed. Yes.
Highly obliged.
Your Lordship, I beg to mention item 36. Your Lordship. I've taken the consent.
Yes, 2 weeks, yes.
Obliged, Your Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention of item 40.
Item?
40, Your Lordship.
40.
40. Lordship, the rejoinder will be filing in the course of the day.
Who's the other
It's
side?
ready, Lordship.
Did we allow you to rejoinder?
Lordship.
In the course of hearing? Yes, so I'll put the list.
This matter was fixed for hearing, Your Lordship.
Okay, but
today.
were they allowed
Because
to file
they had
rejoinder
failed
in the
to file
meantime?
rejoinder for the last
Lordship,
3-4
yes, in the
weeks.
meantime, we have been allowed, Lordship.
No, allowed.
Lordship,
Okay, the list after 1 week. Your rejoinder is not filed today.
Lordship will
not
be
be
filed
accepted.
today.
Yes.
Lordship.
Yes.
Your Lordship, I beg to mention item numbers 37 and 38. Your Lordship, I pray to take up this matter after 2 weeks.
37, 38, on whose behalf?
On behalf
Petitioner,
of...
what
Yes.
happened?
Yes, Your Lordship.
What's the matter about?
It's a Gaubura matter. The item number 37 and 38, it's a matter of Nokma.
Okay, very good. Yes, 2 weeks. On the petitioner.
May I please, Your Lordship? I beg to mention item number 33 and 34, Your Lordship.
What happened?
I humbly pray that this matter be taken up next week, Your Lordship.
Where's other side?
I have tried to...
You tried to inform them or you
Yes.
inform them?
No, I have tried to inform. I'll be informing in, Your Lordship.
Okay. 1 week?
Yes, Your Lordship.
Yes.
Much obliged, Lordship.
Yes, yes.
I need to I mention item number 30.
Number?
30.
30?
30.
Why?
The conducting counsel is undergoing the surgical treatment.
Where's the other lawyer? Isn't that Mr. Nongpur? Where's he? Who assists her?
Mr. Nompier is out of station here.
This matter is very serious because there are very serious allegations against the council. Yeah.
Kindly, you've got 2 weeks, Your Lordship.
Lordship, no objection.
The Maja exporters. When? After 1 week, okay?
2 weeks, Your Lordship.
Very serious matter. Yes, Dr. Mosika, 2 weeks. Where's Mr. Paul? Oh, you're
Lordship,
there.
I'm on his
No
behalf.
objection?
No objection, Lordship.
2 weeks, yes.
Highly obliged, Lordship.
Item number 1.
Yes, what's
Yes,
this?
Lordship.
Yes.
Lordship, this is regarding transfer matter, Your Lordship. Here I
Transfer
was,
matter?
Lordship.
Why?
Actually, Lordship, I was posted in the Nomalbi as a veterinary
Just give the
officer.
reasons why you challenge
I'm giving the reason is because there are 3 reasons. Another rule. So
First reason, okay.
The
say
reason
first
is
reason.
because the one is I'm having a 1 year old child baby, and second reason I'm saying that
First
because
reason
all
is
parents
1-year-old baby for reason.
Reason because I was not difficult for me because I'm alone to be there in the Nongal Bibra, because now right now I'm posted in the Garbada, because even my all parents are also there with me, and parents are very old. There is no one is there to look after my old parents, and that is a second reason.
Second reason, old parents.
Parents also is with me, and I'm nobody.
Third reason.
That reason there is a rule, Your Lordship, which I found that as per the government memorandum 21 February 1983, the government has three categories. Number one, A categories, that A categories belongs to the person should be transferred to the Shillong Joy, Shillong Tura and Joy. Another B is B include the Nongstin, William Nagar, Bakmara, Mairang, Chirapunji, Rishibelpara, and Nongpo. Now the third, I'm in the third category, C category, which is not included. In the third category, as per this one, the government, with the intention of this one is that government officer will get an opportunity to serve in every in all the other department. Now I have been in the C category since in the year of 2000.
So you want to come to Tura?
Because it's a violation. Now, again, I'm transferring prior when I was serving from 2016 to 2022. I was in Nongal Bibra. Then after that, they transferred me. Now again, sending back to the Nongal Bibra, because it is against the violation of rule. And again, another rule also is that.
Have you annexed that rule here?
I have enclosed it, Lordship. It is annexure 30. 30? No, annexure 30. Page. I'm sorry, page 20. Page 30. 30. That it start from 29. There is a 3.1. Yes. May I read, Your Lordship? It is starting from page 29. Let me see. Page 29.
3.1 categories.
Lordship, the categories of different places of posting of state government employee holding transferable post was considered by.
It's just a policy. They said that you should have opportunity to serve. You know that once a government servant is serving a station, should have opportunity to serve. Suppose you're serving Tura, to serve in Shillong, to serve in Jowai also. It's not a hard. It's not a question. It's not a transfer policy. Yes.
Another
next reason.
Yes, another in the same rule also. I just want to complete that that person should not be allowed to serve more than 5 years. After 5 years, they have to send it to different, not to send to the same places. Now here in this case, I have served in Nongal Bibra more than 5 years. Again transferred to Garbada. Again now sending back to the place where I have been transferred and served for more than 5 years. And the third point, Lordship, I have also filed a very effective and meaningful representation, Your Lordship, stating all the reason and the grievances.
Native village is Garobada?
Lordship, yes.
From Garobada herself?
Garobada, yes.
Where is she from?
Actually, at present, I'm staying in Tura.
Oh. That's right.
Garobada is quite near for me because going from Tura to Nongal Bibra, because as a lady, and having a child is very difficult, Your Lordship.
Then you can resign.
No, Your Lordship, I have also filed a representation explaining the detailed difficulties.
Those are all the reasons. 3 reasons. 1 year old baby, old parents, and it's against the transfer policy, you say. Those are the reasons.
Yes.
That's it.
Yes, I have stated at this filing this one. At least let them respond to my application, because I have given the genuine reason, Your Lordship. Genuine reason. Because...
Now, Mr. Sangma, you have not alleged anything else. That's all. No.
We are not alleging.
No malafide, no mischief, not as a punishment, nothing.
No. Yes, I have mentioned at least it's like a punishment sending.
No, not like a punishment. It's been in lieu of punishment. You've been given transfer. No.
I not as a punishment.
There's no ground for interference.
Because honestly saying, I did not say
everybody has babies. Everyone has old parents.
But this is very...
You have left your old parents and also you're coming here. So, same thing.
The Lordship, here I am only one... At least let them respond to my application, then came this... Because
give them liberty to consider, that's all. Yes,
Lordship, she has been in this Garabada for more than 3 years.
Right, yes,
and this representation is only dated 21st June. There's no malafide in the transfer.
That's all. That's fine. Pick down. This application has been filed praying that transfer order dated
19, my lord.
19th of
19 June 1906.
19 June 2024.
2024, wherein the Petitioner has been transferred
Yes,
from...
serial number 20.
Where in the petition? Where's the annexure? Sorry.
Annexure 26, large serial number 20.
Yes. 26. Thomno Babalan. Now this you see your prayer. $19.6, correct?
Correct, Your Lordship.
See your prayer, set aside and quash impugn. Now this transferring about 30 officers. You want to quash all the transfers also?
There is a mistake in my prayer, but what I mean is that I should not.
What will other officers do to you then if you want to stay the entire notification?
Yes, of course. Actually that prayer is.
Okay, take down. I'm just in jest. Yes, Thomno. As far as it concerns the petitioner, wherein she has been transferred from Garo Bada Veterinary Dispensary to Nangal Bibra, Garo Bada Veterinary Dispensary, West Garo Hills, to Nangal Bibra Veterinary Dispensary, South Garo Hills, be interfered with. Stop. Next parameter, PT Sangma submits that the reasons that the petition approached this court is firstly, the representation that has been filed has not been answered, and secondly, she has grave personal reasons, such as, where have you written?
Your Lordship, I have mentioned that is having
paragraph?
Paragraph 5, Lordship. Paragraph 5, I have given one A.
Yes, as she has one.
1 year. And paragraph 5.3.
Inasmuch as she has an infant, to look after, as well as her old parents. Stop. He however very fairly submits that no other allegations, there are no other reasons seeking interference or transfer. Stop. Next, MST Yangi Leonard AAG so submits that the transfer is routine, as it also is in respect of other officers who have been transferred the same notification, and the same being routine and incidents of service, no interference is called for. Stop. File accounts for the parties and consider submissions of the petitioner. Stop. As there are no allegations of any malafide, common mischief, or that the transfer from punishment. Moreover, transfer being an instance of service, no interference is called for. And the petitioners close dispose of the stage. Stop. However, the representation, as the petitioner has filed a representation, it's expected that the same be given due consideration within a period of 2 weeks.
Lordship.
Okay.
Lordship.
Item number 2.
What is this?
Lordship, my senior is also there, available on VC.
Who's your senior? There's a caveat. You're on caveat?
I'm on caveat.
No, caveat. Go on. Yes, who's your senior?
Mr. Biriko. He's a participant. He's there.
Yes, seen the caveat application. Number 57, 2024, final instant appeal. The counsels for the caveat are present. Caveat stands discharged. Yes. Yes, Dr. Malika.
But this matter arises out of a civil suit, my lord, filed by the respondents, alleging certain trademark violations, my lord.
Yes.
My lord, both the parties are producers of cashew nut, my lord, in Meghalaya, and they have respective registered trademarks, my lord, brands.
What are producers of cashew nuts?
Cashew nut, my lord.
In Meghalaya?
In Meghalaya, my lord.
Okay.
They are from Garo Hills and we are in Banihat, my lord.
Yes.
So, my lord, they filed a civil suit in the year 2019, my lord, in the Nongpo court. And an injunction order was passed by the Learned Trial Court. Lordship will find
2019, the suit's 2019?
My lord.
Okay.
In fact, 18, my lord.
Yes.
An initial injunction order was passed on 8/3/2019, my lord, by the
Where is that?
trial court. Lordship, that order starts at 8/3/2019, my lord.
Page 58.
The operative part, your lordship will find page 63.
Trademark infringement?
My lord.
63, okay.
Page 63, para 8, my lord.
Yes.
It says, well, as contended by the counsel for the plaintiff petitioner, that the defendant's opposite parties has illegally adopted the registered trademark Mega Keshu of the plaintiff petitioner on the pouch, and further the counsel for the defendant opposite party have no objection in respect of the said pouch. Therefore, the defendant opposite party is restrained, whether by themselves or through agent, assigns or so and so, from selling products in pouch packets labeled similar to the plaintiff petitioner's registered trademark Mega in any packing having a similar and or deceptively similar to the plaintiff petitioner's registered trademark Mega.
Yes.
My lord, thereafter, because we are selling in pouch as well as tin pack, the larger packets of 10 kg in tin container, my lord.
Tin containers?
Tin container. And these are the small 50 grams, 100 grams in pouch packets, my lord. So the restraint order was confined to the pouch packets, my lord.
Okay.
My lord, thereafter they filed an appeal against this order. They came before this honorable court, my lord.
Why they came?
Because they wanted
in their favor?
They wanted restraint also on tin, my lord, number one, and number two. So primarily, and number two, they were also agreed with the fact that there was a certain violations after. There was some breach of injunction on our part. That was their allegation, my lord.
Yes.
My lord, this honorable court by page 94, lords will see. Order passed by lords, this honorable court, my lord.
Yes. But,
my lord, basically, this honorable court said, my lord, at para 3, learned counsel claimed that the defendant has violated the aforesaid order. It was further stated that the plaintiff appellant shall take appropriate remedy under the provisions of Order 39 Rule 2A of the CPC or any other provision of law in accordance with law. In view of the above, it was prayed that the appeal may be disposed of as such, ordered accordingly. The registry is directed to send back the record of the trial court, wide orders dated so and so. The original bills produced by the learned counsel for the appellant were put in seal cover. It is further directed that the two sealed envelopes be also sent to the trial court, who shall open the same and may take into consideration in any further proceedings in the matter in accordance with law, so and so. Thereafter, my lord, they filed an injunction violation application at page 98, my lord, in the year 2019, my lord.
98.
98, my lord.
Yes.
And this matter was pending for about 4 years or so, my lord. And ultimately, the final order came to be passed, my lord, the impugned order at 115, my lord.
So where's the finding?
My lord, finding, your lordship, kindly come to page 124.
Yes.
Para 16, the conclusion.
Yes.
On careful perusal of the application filed by the petitioner, apart from the pleadings made therein, there is nothing to indicate or prove that the said pouch packets were manufactured in the month of June 2019 by the respondent. On the other hand, the respondent has clearly admitted that due to bona fide mistake, they wrongly packed the goods in the pouch packets during the month of June.
Admitted in which fashion, in which manner?
Well, also, my lord, what is the admission? In our reply, can that be construed as an admission, my lord?
Yes.
The burden to prove such willful disobedience of the court's order dated so and so lies with the petitioner. But in this case, although in the absence of material, the respondent has candidly admitted that such act has been committed by them and it is not known whether it was done intentionally or unintentionally. Also, during hearing, counsel for the respondent has tendered his apology. Very startling, my lord, so kindly see. Therefore, it is established that the respondent has flouted the order dated 8/3/19. It is the duty of the court not to allow perpetuation of wrongdoing and also to uphold the rule of law. The proceedings under Article Order 39 Rule 2A are meant to maintain dignity of the court in the eyes of public and to deter unscrupulous elements from flouting the orders of the court. The apology tendered by the respondent is hereby rejected on the reason that if the court allows such apology, then it will virtually let the respondent to go scot-free and they will achieve what they have set out to do. Even in the open court, the counsel for the respondent has repeated the apology, but this court does not find any reason whatsoever to accept the same. No litigant should get an impression that he can disregard the orders of the court with impunity and then get away by merely tendering apology. But upholding the majesty of law, this court directs the respondent to pay a fine of Rs 5 lakh as a penalty for breach of the order dated 8/3/2019. The respondent shall deposit the amount before this court within a period of 2 weeks of this order, and the petitioner shall withdraw amount from so and so, so and so. So, my lord, the learned trial court has relied on two things, my lord. First, they are saying that there is a admission, my lord, and number two, that we have tendered apology, my lord. My lord, tendering apology is in a different context, my lord. When there is injunction violation or contempt application, we tender apology, unconditional apology, my lord. My lord, whether that can be taken into account to penalize somebody, my lord. And lordship, as far
Do
as
you agree with the 5 lakh penalty?
my lord, here what happened, my lord?
What's the stage of the suit?
My lord, in fact, we filed, because here what happened, my lord, we also have a registered trademark, my lord.
Now, what's the stage of the suit?
For framing of issues on 3rd.
So, frame issues from 2018, the suit been filed.
It was pending because of the pendency of this injunction petition that was to be heard on merits. So both the parties appeared, they filed their objection, and thereafter it was passed in reasoned order.
Well, factually, what happened, my lord, the cashew market, maybe in 2018, when the suit, there was some market, my lord. After 18, our unit is almost defunct unit, my lord, at this stage, my lord. And to penalize by with an amount of 5 lakh rupees, my lord. That
Why defunct unit? I just saw in the news that day that Meghalaya is one of the top 10 cashew producing states in the country.
But cashew processing is one thing, my lord. The processing business is not doing well, my lord.
Okay. Yes.
And we are not selling anything since last 4.5 years.
And my lord, this violation, whatever happened, my lord, that was of June 2019, my lord. And that also the violation, my lord, they produced certain empty pouches before this honorable court, my lord, saying that we violated the injunction order
Before this court.
Before the High Court, my lord. And those were sent back to the trial court. But the learned trial court comes to conclusion that there is no evidence that these were actually packed in violation of the injunction order of 8th March 2019, my lord.
No, but in the packaging material, that doesn't indicate the date.
Well, that's the finding of the trial court,
the
my
thing
lord.
is that, I don't know.
My lord, the finding of the trial court...
There was no preliminary kind of issue fixed on this, whether you violated or not, or because it will be a matter of evidence, it's trademark.
My lord, the finding of the trial court is that there is no evidence apart from pleading, my lord.
Okay.
So, in the absence of any other material, my lord, to come to a conclusion that there was a violation, my lord, simply on the basis of our admission, my lord, on the basis of purported...
Only this paragraph 16.
Paragraph 16, my lord, that's the conclusion of the trial court, my lord.
Okay.
So,
Yes,
my lord,
Mr. B.D. Kaur. Yes, what do you want?
My lord, at this stage, what I pray, my lord, the appeal can be admitted and some interim protection and matter may be heard, my lord, on the next date.
Yes, Mr. Kaur.
May it please, Your Lordship.
Are you in space or where are you?
No, I'm in Delhi. The background that you see is a virtual background because I'm in my doctor's.
I understand, yes. You're jazzing up the background, yes.
Your Lordship will see that so far the injunction order is concerned. There is a clear admission that they say that we have directed the managers and our agents to, but it was a bona fide mistake and it was committed and they admitted. Now, when there is a principle in this type of matter, it's his duty to see that his agents, managers follows the injunction order. We are not required to make each and everyone a party in this proceeding because ultimately the injunction order was directed against the manufacturer. And your Lordship will find from his pleadings that he claims himself that he is doing business of 7 to 8 crores. And that too on a trademark which is deceptively similar to us. So I think that matter, so far this amount is concerned, instead of, I can at least concede to that extent that at least they should deposit 50% of this amount before this honorable court for admission of this appeal. And let it, will also not withdraw it, let it be the outcome of this case. But at least they should deposit some amount before the registry of this.
Yes, Lord Mozika. Deposit 2 lakhs.
1 lakh, my lord.
Deposit 2 lakhs, yes.
1 lakh, my lord.
2 lakhs, yes. Heard Dr. M. Mozika with Mr. A. Khan. Stop.
Here our unit is here where we will escape, sir. We have got the unit.
Mr. Khan, you engage a counsel, I think, to submit. You're going to give stereo submission, yes.
1 lakh, my lord.
Okay, 1 lakh 50. Yes, heard Dr. M. Mozika with Mr. A. Khan. This is an appeal directed against order dated 22/5/2024. passed in Miss Case number 1 of 2020, arising out of TS number 1 of 2020 by the Court of the District Judge, Riboy District, Riboy. Yeah, stop. Next part, Dr. M. Muzika submits that the appeal is primarily against the cost imposed upon the appellant for alleged breach of trademarks. Stop. He therefore prays that the matter be admitted for consideration, especially on the quantum. Stop. Next by Mr. B.D. Kumar with so-and-so. For the respondent has vehemently objected to the prayer and submitted that if the matter is to be taken for consideration, the appellant should at least deposit 50% of the cost amount before this court, before the registry of this court. Having considered the matter and as it deserves, as the matter deserves further consideration, the Mrs. Appeal is admitted for Mrs. Appeal is admitted for hearing, subject to the payment of deposit of 1.5 lakhs before the Chief Court, before the Registrar General, by
10 days.
By within 1 week. Yes. List thereafter, records to be called from. Do you need records or not necessary?
Not necessarily. Your Lordship will kindly indicate that the trial court proceeding
records
is
may
not
be called, but the
stayed
matter has been disposed of, my lord.
Yes. But the miscase records can come, let the trial court proceedings commence. I mean, yes, let the records for the miscase be called. Stop. It is made clear that the proceeding to main title suit the proceedings shall continue in the main title suit. Yes. List after?
Yeah. In the month of August, yes, subject to your Lordship's convenience.
Yes, list month of August.
Deeply.
My junior will chat again. I'm obliged.
Item number 3.
You supply your names, yes.
Please, Your Lordship.
Please, Your Lordship. I'm appearing on behalf of respondent number 3 and 4. I'm praying for some accommodation for today, Your Lordship, as we need to obtain necessary instruction.
You have to pay her, no? You're paying her. Regarding payment of salary?
No, my lord. This is one WPC is regarding the constitution of the managing committee. The second WPC connected with this matter is with regard to demotion from the head teacher to the assistant teacher.
Oh, sorry. Yes.
Should be paying for some accommodation for today.
Why?
For a week time.
Were you supposed to file affidavit?
Lordship,
What do you want?
Pleading is complete, my lord. It's fixed for admission hearing.
We're paying for 1 week time, Lordship. Lordship, he's here, but we need to obtain some instruction from the parties, Lordship, regarding this matter.
No problem. Ms. Iwan Yang submits that as some instructions need to be obtained.
Some instruction, Lordship.
When?
After 1 week, Lordship.
Yes, she done the matter be taken for 1 week, yes. Or she prays the matter be taken for 1 week.
For admission hearing, my lord.
At least a matter of 1 week for admission hearing. Yes.
Obliged, my lord.
As a instruction, she prays that the matter be taken. Yes.
Item number 5.
As some person submits as she prays the matter be taken for 1 week. Yes.
Item number 5.
Yes.
In terms of the last order, Lordship, we have placed the order, Lordship, passed by the MSCRC, Lordship.
Where's the order?
Lordship, I have shared.
So the matter is still hanging fire like that. Lordship. There's been no effective orders with regard to what tariff should apply.
No, Lordship, because
in
now,
the interim
Lordship,
also nothing.
The chairman is has retired, Lordship. So
what to do, Mr. Pandey? This was disconnection.
Lordship, temporary disconnection.
Because your Lordship's order was there of 15th February of deciding this matter expeditiously. Well, also time frame may be fixed and
how time this he says there's no chairman.
Lordship, no chairman, Lordship, as on date.
This was disconnection.
Lordship, temporary disconnection. And there is, Lordship.
You've already admitted that they've already disconnected the power themselves.
Yes, my lords, they have admitted it that they have not followed the regulations as far as disconnection is concerned, my lords.
Lordship, it was
so
not,
they don't have a
Lordship,
right.
It was not disconnection, Lordship.
Where's Mr. Paul?
Lordship, he has some difficulty today, Lordship.
We'll listen tomorrow. Lordship. Yes. Let him be there. Let
because
him be. Yes,
will also then have not tomorrow, will also on Wednesday, will also day after.
Wednesday, let me holidays. Okay, Thursday. Let Mr. Paul be here, yes.
Item number 6 is a connected matter, Lordship.
5 and 6 will also connected.
7.
Obliged.
He's standing.
Yes, Your Lordship.
After 3 months. Mr. Archival General, after 3 months, this one border boundary dispute. Yes, I see order. After,
yeah, I'm sorry.
After 3 months, yes.
8.
Item 8 is contempt, my lord. At Marble. Okay.
Lordship, in terms of the last order, Lordship, in terms of the last order, we have paid the cost, Lordship, and we are in the process of filing the affidavit in the course of the day, Lordship.
You haven't filed affidavit yet?
Yes, yet, my lord. And they are not paying rent also, my lord. They are not paying rent also.
It was the order was, Lordship, subject to payment of cost. So, Lordship, I may be allowed to bring on record the payment, Lordship, that I have already deposited, Lordship. And the affidavit is ready, Lordship. Will be.
Because they are not paying the rent also, my lord.
We have already served the advance copy as well, Lordship.
Okay. Mr. Chandra has produced a receipt indicating payment of cost of rupees 5,000 to Shillong Bar Association. He first admits that after be filed the cost of the day. According to this matter, after 1 week.
Lordship, within this week, my lord, because they are not even paying the current.
Let's the matter on Thursday. Yes.
Hello.
Item number 9.
You joined the file?
I'm praying for 2 more weeks, Your Honor.
Why?
Lordship. Sometime we need some help here.
You joined as necessary?
Yes, Your Honor.
But he said there's a judgment that operates in your favor with regard to the school. Mr. Qureshi had said, I think. Some judgment passed by this court only.
Your Lordship,
showing
only
who's
2
the
more
sponsoring
weeks,
body.
we will be filing the rejoinder.
Okay, yes, Mr. Basumatari. Please will allow further 2 weeks time to file the joinder. Prayers allowed.
Deeply obliged, Your Lordship.
10.
Mr. Bora was here outside.
There's a Bora like doing guerrilla warfare. He disappears and appears. Yes, Mr. Bora. You file objection?
Yes, I have received the objection.
What's the objection? Just for condemnation, how many days, Mr. Bora?
1,686 days.
1,000?
Totally from the date of the imperial order of the lower court. Now, actually, the real delay was up to 28th March 2018. Thereafter, all the proceedings.
When was the judgment with the judgment of trial court?
12 September 2017.
12 September 2017.
17 is the order. Then I went with a wrong presumption. I filed the petition first after that day on 20th March 2018. Thereafter, all the proceedings had been on a wrong way, actually. In the show cause, the respondent has mentioned one point that that order was passed under Order 9, Rule 8. Whereas, in fact, that order was not passed under Order 9. That is because on that date, the case was not fixed for hearing. Defendant was present.
You filed an application Order 9, Rule 9.
That was by mistake. I had filed on 20th March 2018. Thereafter, all the proceedings went on the same line only. because of that original mistake. Both parties presume
now see
that the order was
Mr.
under
Bora, how
Order
can
9
you,
Rule 8.
now this is, you file under 227, this one. This applicant for the court 227 now.
Yes. This in this condonation, I have started the calculation from the date of that order.
No, now you file under Order 9 Rule 9, correct?
Yes,
Your application before the trial court.
That was my mistake, I said.
Then how are you going to correct the mistake by come to 227 here?
That is what is the revision for. Because the order, first of all, the order was not, order is a nullity because that was an order passed against a dead person. We did not realize that one at that time. That's why I filed a petition under Order 9 Rule 9. And again, second point is that that order was not under Order 9. That was under Section 151. Because that date was not fixed for hearing. So that order
Notwithstanding anything, now when you file your application 2018, Order 9 Rule 9 or whatever application, how many days delay was there after your case had been dismissed?
So that petition was disposed in 2022.
No.
After the COVID period.
No. What date did you file under Order 9 Rule 9 application? Which date was that?
Actually, I did not file. Originally, I did not go with the Order 9 Rule 9 application. I had gone with the Order 22 Rule 3 application for
when did you file any application after it was dismissed?
In the court, I came to know that it was dismissed before, so I added Order 9 Rule 9 by hand.
Okay, it was dismissed for default, correct. What kind of application, whatever application, when was the date you put it before the trial court?
That was about 591 days late. On that date, I was 591
See, notwithstanding anything, we won't look at your applications, whatever you file, but the time like you had gone, after a year, after it's dismissed for default, you went again to the court, that means.
For that, I had come 591 days delayed. Now, that is within the limitation period, if we know that that order was not under Order 9.
Doesn't matter. We're not looking at the correctness of the orders, Mr. Bora. We're looking at the procedure, right? There was an order passed in 2017.
Right.
17. Now you didn't do anything. You slept over it. In 2018, one fine day you went and put some sort of application.
It happened like this, my lord. On 3rd April.
No, I'm not. We just
there
saying
was an
that.
order. Thereafter, the case was fixed for.
Now you cannot make out
amendment.
a case on technicalities that okay, fine, it was dismissed
Before
under
that,
Order 9 Rule 8.
Before passing out the order, my lord, the plaintiff had expired. And I had no, as advocate, I didn't know about it. And his siblings were not aware that there is a case. They were busy with their funeral and all.
For 1 year?
No, about 5 months. He died in June 2017. And people were busy in his treatment and all.
If the delay,
then when he came to know in March,
time, whatever application he went in, maybe under 227 will try to correct it. But then,
when his son came to know in March 2020 that the case is still there, we have to substitute.
Yes, Nombri.
Until that is 591 days only, that is within the limitation, because the limitation will be covered by Article 137 of the Limitation Act. Because that order was not under Order 9. It was under Section 151, the dismissal order.
Yes.
Lord, his remedy was, my lord, Order 9, Rule 9, my lord.
Yes.
He had filed Order 9, Rule 9 without a delay application.
That was the mistake, my lord, because the order of dismissal was not under Order 9, Rule 8. It was under Section 151. Because that day it was not fixed for hearing. Defendant was present, plaintiff was absent. It was not fixed for hearing. If the court has passed any order of dismissal, that would be under Section 151.
No, my lord. No, my lord. It has come by way of my affidavit, my lord.
Where is it?
In his affidavit only he has said.
The application, your application under Order 9 Rule 9. Where is it?
That is with the main civil revision petition. That's page.
Come done. Okay. We'll
page.
See, one thing, the records are not here. You come on Thursday. We'll just dispose of. But then, Mr. Bora, try to make out some case. Otherwise.
11.
Yes, affidavit file.
Yes, Your Lordship.
Very good. Yes.
To come for hearing.
Not necessary.
Not necessary.
Yes, MSP Chetty submits that affidavit since been filed at the pleading stop.mosica. Then senior counsel has no rejoinder be necessary. Calling the matter for hearing.
12.
Your Lordship, we pray for some more time, Your Lordship. Respondents 1 to 3 to file affidavit.
You file the affidavit? Course of the day? For vetting? Okay, no objection, Mr. Ahmed. Mr. Sen's not here today?
He's there.
Yes, Ms. Yangi for Leonard Sonso for 1 to 3, Ms. Chanda for 4, brief followed. Further?
3 weeks' time, Your Lordship.
3 weeks' time to file affidavit. Just
And
after also.
13.
Make to your lordships.
Yes.
Lord, in this case, recently, Lord, the bank respondents have filed their affidavit, and Lord, the RBI have been served. Lord, we have also filed an affidavit of service, and Lord, just we are seeking 2 weeks' time, Lord, because your lordship would consider the interim period as well as the final it could be disposed of, because they have taken a stand on the basis of the circular. Lord, that has been stayed by your lordships, lords.
May I please also? I have an instruction to appear on behalf of the Reserve Bank of India. That's number 8, 9, and 10.
Let them.
We need some time because it will come from Mumbai, my lord.
How long you need your Mr.?
We are praying 4 weeks time, my lord.
So your name?
I am P. Hazarika.
Okay. So you're entering appearance today only? First
Yes.
time, yeah. Mr. P. Hazarika, Leonard Counsel.
We are not filing the Wakalatama. It's coming from Mumbai. We need some time.
Appearance behalf of respondents 8 to 10. So service is complete, that means. So such service is complete on all the respondents. He submits that, or he prays without how much time?
4 weeks time.
4 weeks time to file the affidavit, as the instructions have to come from Mumbai. Stop the prayers allowed. What else do you want, Mr. Dubey?
Lord, I seek time for filing a response since RBI will file and their pleading should be complete. So thereafter a week's time, Lord. Thereafter,
yes,
I can file my response.
after the affidavits are complete, counsel for the press allowed 2 weeks time to file rejoinders there too. You file one rejoinder to all the affidavits.
Maybe this is your lordship.
That I'll
As
do.
state is concerned, lordship, we will
But there is an
rely on
interim order that needs to be. The earlier interim order needs to be completed.
14.
But the earlier interim order needs to be
granted 4 weeks time.
Yes, 4.
Oblige.
Please, Your Lordship. Your Lordship, as per the last order, we are required to file the affidavit. My Lord, we are yet to receive instructions in this matter. Can you grant me some time, my Lord, to file the affidavit?
Why? See, if it's written like that, expected next date affidavit to be on board. Who's the officer responsible for instructions? What's the matter about?
Non-payment of salary, Your Lordship.
Driver against vacant post. Which department? Piluri?
Yes, Your Lordship.
Why can't instructions? Where is he posted? Bakmara. Mr. Panja, please work out for 2 weeks time to obtain instructions and file affidavit. Yes.
Do you believe like?
Hearing. Item 15.
Item? For the appeal. What on the notes, huh? Mr. Sen, you reply.
Lordship.
You're replying today, right?
Yes, sir.
Hi, Babalan.
So it was last argued on 25th of
Yeah, 25th June.
25th June.
Yes. You've answered on
the 2 points of maintainability.
Maintainability of the composite appeal, and also whether the collector is a representative of the state.
Lordship. And whether he's required to file a vakalatnama.
Right. Now, yeah, you refer to 2009 3 SEC.
No, well, it's two judgments. One is 1995 5 SEC. That is a deputy commissioner.
5 SC, the 333, 2003 3 SC 128.
Yes, my lord.
And on maintainability of composite appeal, 2015 3 SEC 624.
It's there, in fact.
Yes.
2015 was a judgment that my learned senior had referred to. I had distinguished that.
Okay. Just refresh a bit, we can continue.
My lord. So just on those 2 points, one was that a vakalatnama is required to be filed on behalf of the collector. My learned senior had referred to a judgment of AIR 1978 Goa Daman Diu.
That's been overruled.
That's been overruled by the Honorable Supreme Court. And number 2, that in the case of Sharda Devi, the Honorable Supreme Court had made it clear that the collector is only acting as a representative of the government.
Okay.
And he conducts the entire proceedings on behalf of the government. So therefore, he's a public officer. Now, when I had started, when it was on the 22nd of May, I had started by attacking the judgment on 4 grounds.
Yes.
My learned senior has advanced his submissions. In response to that, I'm just offering some clarification on this, a small rejoinder to that. That's the first ground was that the court had granted maximum uniform rate towards the market rate. And it is our argument that there is no justifiable reasoning in the impugned judgment to support that. So the court granted the maximum uniform rate without examining the individual entitlements of the landowners. In support of this, Lordships will recall, I had referred to a judgment of Haridwar Development Authority versus Raghubir Singh.
The maximum compensation awarded without
any reasoning, my lord. So the court basically held that if somebody else has been granted 60 and someone else has been granted 220, there should be parity.
Okay, yeah.
And on that ground, the court granted maximum uniform rate to all the parties. So this, in my humble submission, goes against all the settled principles with regard to determination of market value. In support of this, I had relied on a judgment of Haridwar Development Authority versus Raghubir Singh, which also speaks about the belting method, if Lordships recall. There are different ways in which the court should examine how the individual entitlements should be decided, how the market value should be determined. Now, in response, my lord, my learned senior has argued that in the event the state decides to acquire a property for a single purpose, in the instant case it is for acquisition for the purpose of a highway, then in such a case classification of land is not necessary. This is the argument. There's a problem with this argument because this contradicts their case before the trial court. Now, before the trial court, my lord, they had themselves prayed for classification of the properties and they indicated the rates that they were entitled to. Kindly have paper book 1.
Yes.
Look, I'll refer to the judgment. There are certain observations made in the judgment dated 17/3/2020. Kindly have page 134.
134.
134.
Yes.
Let's kindly see right at the bottom, your lordships will find certain rates.
Homestead.
Yes, and just kindly look at 4 lines above that from the bottom. It begins with hence that the claimants approach this court.
Page 134. Yes. The claimants approach this court for
It says the claimants approach this court for enhancement of rates, and all petitioners write their representation dated 16/12/2002 paper mark 7 exhibited by the petitioner number 1, common to all petitioners, claimed the following rates: for homestead 4,000, for paddy fields 10,000, for arable land 4,000, for quarry land 4,000. So this was their case before the trial court, and the trial court has recorded this. So they themselves were advocating the issue of classification of land. However, before this honourable court, they have contradicted their own case. And the new proposition sought to be advanced is that in the case of acquisition for a single purpose, classification is not necessary.
Yes.
In support of this, my learned seniors refer to 2 judgments. The first is at page 47 of their compilation. Page 47.
Yes. 2018.
2018 SEC on N, HP 928. During the course of the hearing, Lordships had expressed disinclination from referring to this judgment. The relevant paragraph is at page 48, para 9. Para 9, my lord.
Yes.
This reads, land was acquired for construction of road.
This is the belting method. This is the belting method.
No. Belting method is what I had referred to. This is the judgment of the Himachal Pradesh High Court, which my learned senior had referred to. Yes. This reads, land was acquired for construction of road. Another plea of the state to assail the award on the ground that compensation was to be determined on the basis of classification and category of land is also not tenable for the aforesaid reason, as the same was not agitated in the previous appeal. Even otherwise, it is settled law of the land that when land is acquired for a purpose which has no relevance with the classification of land, like construction of road, the compensation is to be paid at a uniform rate for all kinds of land, irrespective of its classification. Now, this does not refer to which case law has actually settled that proposition. The next case law referred to is at page 60. This again is a judgment from the Honorable High Court of Himachal Pradesh. And one of the relevant page is at page 69.
Yes. Page 69?
69. Page 69 is the relevant page, para 9. If Lordships have it?
Yes.
Para 9. This reads, Manoj, it is no longer res integra that when the land is acquired for a purpose of single use, which has no relevance with the nature and classification of land. Para 8, Manoj. As per provisions of section 25 of the Act, the reference court cannot determine the value of acquired land at a rate lesser than the rate awarded by the land acquisition collector. In the present case, the highest value determined by the land acquisition collector is rupees 7,500 per biga. And in light of the aforesaid provisions of the Act, the value of the land acquired cannot be determined below 7,500 per biga. It is no longer res integra that when the land is acquired for a purpose of single use, which has no relevance with the nature and classification of land on the basis of its agricultural potentiality, its value is not to be determined on the basis of its nature and classification, but has to be determined on the basis of purpose for which it has to be put in utilization after acquisition, considering the entire land as a single unit, resulting awarding of uniform rate to all kind of land acquired. Now, this has reference to certain cases. Will not kindly see Daduram versus Land Acquisition Collector, 2016 ILR 636 HP. Again, Himachal Pradesh. HP Housing Board versus Ramlal, 2003 3 SEC Shimla. Union of India versus Harinder Pal Singh. So this is the only judgment in this particular decision which refers to a decision of the Honorable Supreme Court. Now, kindly have that decision, my lord. 2005 12 SEC 564.
2005.
2005 12 SEC 564. If Lordships have it, kindly see page 565. In this particular case, we are only examining whether that proposition has actually been laid down. At page 565, kindly see para 2.
All his appeals.
All these appeals relate to the acquisition of 3512.33 acre of land comprised in 5 villages, namely so and so, pursuant to several notifications dated so and so, issued under Section 4 of the Land Acquisition Act for extension of the cantonment at Amritsar. It is not for acquisition of a highway, not for the construction of a highway. Then, kindly see page 566, para 4. This matter went up to the Honorable High Court, and what was the reasoning of the High Court? Page 566, para 4.
Yes.
This reads, while considering the matter, the division bench concluded that the lands comprised in the 5 villages were more or less of similar nature and character and well connected by roads, and that there was a good deal of potentiality for development of the locality. It was observed that the areas in question contained houses and factories and were also close to Guru Nanak Dev University. The division bench also took particular note of the fact that the lands comprising the adjoining village of Kala Ghanupur, which had also been acquired under notifications dated 77 and 10/6/77, were valued uniformly at rupees 40,000 per acre. The division bench observed that the market value of the acquired lands was being determined keeping in view their potentiality for industrialization or urbanization. It was observed further that it had been fairly considered by the counsel for the parties that the market value of the Nehri lands in the same locality is the same irrespective of whether they were nearer or farther away from the town. On such consideration, the division bench, in keeping with the market value of the lands comprised in village Kalaghanupur, was of the view that the market value of the lands under acquisition in the 5 villages should also be fixed at a uniform rate of rupees 40,000 per acre, irrespective of the nature or quality and whether the same was situated near to the road or at some distance therefrom. The reasoning here was particularly based on subjective satisfaction of the court, based on the local circumstances. Now, this matter went up to the Honorable Supreme Court, and kindly have page 568. The reason why this was upheld. 568, para 15. I'll read this part. We have carefully considered the submissions made on behalf of the respective parties, and we see no justification to interfere with the decision of the division bench of the Punjab and Haryana High Court, which in our view took a pragmatic approach in fixing the market value of the lands, forming the subject matter of acquisition proceedings at a uniform rate. From the sketch plan of the area in question, it appears to us that while the lands in question are situated in 5 different villages, they can be consolidated into one single unit with little to choose between one stretch of land and another. The entire area is in a stage of development, and the different villages are capable of being developed in the same manner as the lands comprised in Kalaghanupur, where the market value of the acquired lands was fixed at a uniform rate of rupees 40,000 per acre. The division bench of the Punjab and Haryana High Court discarded the belting method of valuation having regard to the local circumstances and features, and no cogent ground has been made out to interfere with the same. So they looked at local circumstances, my lord. They chose one of the villages which had already been offered a particular market value as a comparative unit for all the other villages.
As an index.
My lord. And so they noticed that all the villages could be classified in the same manner because they had similar characteristics. They did not lay out this proposition that if the acquisition is for a single purpose, then there should be uniform rates. That was never laid down.
Okay, one second. Yes. Yes.
Let's, I would also submit that the very basic principle for determination of market value would be to see first what is the potential price that a property will fetch, that individual property, not all the other properties. In case there is no contemporaneous material to indicate what the price could be, they could look at other factors which could be neighboring properties and what is the price that they have fetched in the past. Now, just to lay that down, let's kindly have the judgment of AIR 1972 SC 1417.
AIR?
AIR 1972 SC 1417.
I think it'll be better if I keep a monitor here, just click on the judgment, yes.
Yes. No. Serial number 7.
721417.
Lordship.
We're done with this?
Lordship. Kindly have page 483, para 4. This reads, the general principles for determining compensation have been set out in section 23 and section 24 of the Act. The compensation payable to the owner of the land is the market value which is determined by reference to the price which a seller might reasonably expect to obtain from a willing purchaser. But as this may not be possible to ascertain with any amount of precision, the authority charged with the duty to award compensation is bound to make an estimated judged by an objective standard. The land acquired has therefore to be valued not only with reference to its condition at the time of the declaration under section 4 of the Act, but its potential value also must be taken into account. So the land sought to be acquired will have to be looked at what it may potentially fetch. So this whole proposition value that uniform rates have to be applied, in my mind, may not be the correct proposition, my lords. Kindly examine and kindly consider, somebody has a agricultural land which is extremely fertile, and what is being sought to be advanced by the respondents is that should be equated perhaps with a wasteland, just because the acquisition is for the same purpose. That's the next judgment is a judgment of the Honorable Supreme Court, 2023, 9 SCC.
2023
9 SCC 315.
Okay.
So page 319 is the relevant page. Para 10 and 11 minute. It reads, the guiding principles for determining the market rate of the land at the date of the publication of the notification under section 4.1 in view of section 23 of the said Act are well settled by this court in a category of decisions. Accordingly, the determination of market value is the process of predicting an economic event, that is, assuming a price a willing vendor would offer to a willing purchaser in normal market conditions, but not an event of anxious dealing at arm's length, nor a facade of sale, nor fictitious sale brought about in quick succession or otherwise to inflate the market value. No doubt, for ascertaining market value of the land, its existing condition, location and user, its proximity to residential, commercial or industrial area, etc. are the major factors to be considered. The size and nature of the lands acquired and size and nature of lands in respect of which sale instances are produced on record also would be an important aspect, inasmuch as normally the sale instances of small piece of land cannot form reasonable basis to determine the market value of large chunks of land unless suitable deductions are made in respect of the development charges. How much deduction should be made would depend on the nature of the land, its topography, special features and state of its development, so as to make it suitable for the purpose for which it is acquired. So therefore again, all properties have to be looked at by their individual characteristics. So this whole issue of granting uniform rate may not be the correct proposition. The second point that I had argued initially was that solatium had been granted.
This is on uniformity of
Yes.
rate, right?
Yes.
Okay, maximum compensation awarded without individual reasoning.
Yes, my lord.
Okay, your next point is on
Solatium.
solatium granted on the entire amount, not
It
only
was granted
amount in
on-
excess of market value.
Yes, my lord. So under section 23, as lordships have noticed, it is only on the market value. So there are 6 factors which the court has to
Only
consider.
in excess of the market value.
Yes, my lord. Only on the market value, not on any of the other issues.
Okay, yes, sir.
So this, I think, my learned senior is fairly conceded.
Yes, okay. Solatium, okay. Yes.
So this is with reference to section 23. Just to refresh your lordship's memory on this. Kindly have the act on it.
Barim. We should give the new act. 89. No.
1894, my lord.
The old act, 1894. Current act. Old act, 1894. Yes. Bolang itu. Kalau the matter is going on, yes. Yes.
So if lordship sees section 23,
Yes.
this provides that matters to be considered in determining compensation. In determining the amount of compensation to be awarded for land acquired under this act, the court shall take into consideration these 6 factors. The first is the market value of the land. And then if your lordships look at subsection 2,
Yes.
it provides that in addition to the market value of the land as provided above, the court shall in every case award a sum of 30% on such market value, not on the entire compensation, only on the market value, in consideration of the compulsory nature of the acquisition. Now, in support of this, I had referred to a judgment of the Honourable...
One second, sir.
My lord.
I think the amount of land assault by the court shall be of 30% of such market value.
Yes. So 30% on such market value only, not on any of the other 5 considerations. So for this, I relied on the judgment of State of Punjab versus Amarjeet, reported in 2011, 4 SCC.
2011? 734.
734.
Yes. Two 2011. Yes.
I'll refer to page 737. पहले वाला 737 paragraph 4 onwards, my lord. Section 23 of the Act refers to 4 distinct amounts. Market value of the land on the date of publication of the notification under Section 4.1 of the Act is the first and foremost of the 6 factors to be taken note of for determining the amount of compensation for the land acquired. It is the major component and in most cases the only component of the compensation determined by the court under Section 23.1 of this Act. Compensation to be awarded to a person for the acquired land is to be determined under Section 23.1 of the Act by taking into consideration 6 factors. And these are the 6 factors that are laid down. I'll skip to para 4.3. Additional amount at a rate of 12% per annum on such market value for the period commencing on and from the date of publication of the notification under Section 4.1 of the Act to the date of award of the collector or the date of possession of the land, whichever is earlier. And 4.4 is important, my lord. Solatium at 30% on such market value in consideration of the compulsory nature of acquisition. While market value and compensation are factors to be assessed and determined by the court, no such judicial exercise is involved in regard to additional amount payable under 23.1a and solatium payable under 23(2), as their statutory benefits payable automatically at the rate specified in those categories qua the market price. No reasons need to be assigned for grant of additional amount or solatium. So this has been fairly considered by my learned senior. Then the next point was grant of interest under section 28.
Excess of 12%.
Yes. So there are two periods that have been specified under section 28.
Yes, sir. Yes.
I'll just take your lordships to section 28. Collector may be directed to pay interest on excess compensation if the sum which in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collect did award as compensation. The award of the court may direct that the collector shall pay interest on such excess at the rate of 9%. So this is the prescribed rate for this particular phase per annum from the date on which he took possession of the land to the date of payment of such access into court. So for that first period, the prescribed rate is only 9%. In this particular case, the court has awarded 12%, which is far and above the prescribed rate. Now, in response, my learned senior has supported the grant of 12%. And as far as the figure of 12% is concerned, they've said it is traceable to section 23. Can you again see section 23?
Mm-hmm.
Section 23, subsection 1A.
Yes.
So as I refer to the judgment of Amarjit Singh, it breaks down the different components. One is the market value and the other 5 heads of compensation.
One second.
Yes, my lord.
Yes, yes.
So section 23.
Yes. Amarjit. Right. No, yes, continue.
So section 23 can broadly be broken down into 3 categories.
Right.
So the first category is under section 23(1), which comprises of the market value, which is the first factor, and the other 5 factors relating to the loss suffered by the landowner.
Yes.
The second category
Yes.
is a grant of 12%, which is under subsection 1A.
Yes.
Can you have that, my lord?
Yes.
In addition to the market value of land as above provided, the court shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of the notification under section 4, subsection 1, in respect of such land to the date of award of the collector or the date of taking possession of the land, whichever is earlier. So what is being argued is that this number of 12%, which has been granted as interest, is traceable to subsection 1A. This is incorrect, my lords, because this is a statutory compensation which is granted. And kindly also see the limitation on this.
Yes.
So it is the period for which it is applicable is from the date of the award of the collector or the date of taking possession of land, whichever is earlier. So it says from the date of the publication of the notification under section 4, subsection 1, to the date of the award of the collector or the date of taking possession. So it is only limited to that particular time period. So therefore it is not interest.
Date of publication of first is section 4.
Yes.
Section notification.
So from the date of the section 4.
Land, section notification and possession.
No, it says from the date of the section 4 notification in respect of land to the date of the award of the collector or the date of taking possession, whichever is earlier.
Okay.
So it runs for a very short period. So therefore it can't be interest. And this has already been held by the Supreme Court that grant of this particular compensation under 1A cannot be equated to interest. Interest is governed by section 28. And section 28 has 2 different periods prescribed. For the first period, 9%?
No, just 12%. Okay. Now, how do you arrive at the amount? 1A. How do you arrive at the amount?
This has not been granted by the court.
In addition.
Yes, in addition to the market
court
value.
shall in every case award amount calculated either at 12% centum per annum on such market value for the commencing on and from the date of publication. Now Section 4 notification comes out suppose in January.
Yes.
Right, and then the collector makes his award on February.
So for that whatever period, whether it's 1 year or whether it's 6 months, 12% will be calculated on
the
that
date
period.
of taking possession. So even if you don't take possession, so your award is made, that means...
So that is earlier.
That is earlier.
That is earlier. So they will be granted from the date of the Section 4 notification till the date of the award. So let's say the Section 4 notification is made in January and the award is made in December.
Yes.
So for the entire period of 11 months, that 12% will be calculated. Now this has a limitation, my lord. It's only for that period, not beyond. So they will not be, if they go by this argument, and I concede to this,
yes,
this will be detrimental to them because it is only limited to this particular period, which is why I was saying it is not interest, and it has been held so by the Honorable Supreme Court. Because I am referring to the judgment of CIT versus Ghansham, 2009.
Yes.
8 SEC 412.
Para?
Page 424.
Yes. Right. No, para?
Page 44, para 29 onwards.
Yes.
Here, read my note.
Yes.
Section 23(1)(a) was introduced in the 1894 Act to mitigate the hardship caused to the owner of the land who is deprived of its enjoyment by taking possession from him and using it for public purpose. Because of the considerable delay in making the award and offering payment thereof, to obviate such hardship, Section 23(1)(a) was introduced, and the legislature envisaged that the owner is entitled to 12% per annum additional amount to the market value for a period commencing on and from the date of publication of the notification under Section 4(1) of the Act up to the date of the award of the collector or the date of taking possession of the land, whichever is earlier. The additional amount payable under Section 23(1)(a) of the Act is neither interest nor solatium. It is an additional compensation designed to compensate the owner of the land for the rise in price during the pendency of the land acquisition proceedings. It is a measure to offset the effect of inflation and the continuous rise in the value of properties. Therefore, the amount payable under 23(1)(a) of the Act is an additional compensation in respect of the acquisition and has to be reckoned as part of the market value of the land. And then kindly see the next page, para 35.
Yes. To sum up.
Yes, ma'am. To sum up, interest is different from compensation. So they discuss Section 28 as well as Section 23, and they hold that solatium, and which is governed by Section 23(2), and this 12% governed by 23(1)(a) are not interests. This is a statutory benefit which is part of the original compensation under Section 23.
Right.
So I think my learned senior misunderstood my argument. I have never argued that this particular that 1A is a compensation. They are trying to trace this amount of 12% to 1A, 23(1)(a), which is not correct. Under Section 23, under Section 28, for that first period, the prescribed rate is 9%. There is no authority to show that the court can grant beyond 9%.
That's it in this point?
Yes, my lord.
The next point is on 50% granted and For the entire period?
Yes, my lord.
From 2003?
So section 28 is to be granted only on the excess compensation. What the court has done in drawing up the decree, it has granted the interest on the entire compensation, including the amount which was originally paid and withdrawn under protest by the claimants.
Okay. Yes.
So I'll just elaborate that, my lord. Kindly have paper book 1. Lordship will kindly have the decree at page 326.
Flag here, yes. You see, this is interest on the entire amount, on the entire
Yes.
period.
Yes.
Right?
Yes, my lord.
On the entire period.
So as part of the judgment, what was ordered was 12%, which that number is incorrect. It should be 9%. But what the court had ordered was that the interest should be granted only on the enhanced compensation. So as far as the award is concerned, to that extent is correct. But while drawing up the decree, the court has committed an error. Can you see page 327? The fourth paragraph, my lord.
Yes.
Claimant number 1 has already drawn the compensation awarded by the opposite party collector under protest on 19/8/2003. The said compensation included amount for land measuring 2106 square meter at the rate of 80 rupees per square meter plus solatium at 30% plus interest at the rate of 12% with effect from 13/9/2001 till 7/7/2003. Here, I must also point out that even the collector went wrong in granting 12% for that period. It should have been 9%. So in any case, Lordship will find the compensation which was awarded, it totaled to about 2,55,685 in the first column. Then in the next page, my lord will find the enhanced rate at 160%, 160 rupees brings the total to 3,36,960. This is just the market value. Then at serial number 3 is the amount granted for lump sum rate for damage to the hybrid tissue cultured plantation. This brings the total to 6,72,000. Then at serial number 4, lump sum rate for the damage to Tita Champa trees, which brings it to 4,48,000. And then at serial number 5, compensation for damage to fencing and compensation for damage to iron grate brings the total to 1,04,140. So in the next page at serial number 6, Lordship will find they have calculated the total enhanced compensation being 15,61,100 without deducting this 2,55,000.
The earlier amount was paid, there is, yes.
Yes, that amount was not deducted.
Yes.
Then in the next paragraph, the court discusses the part of that award. The claimant is also found entitled to solatium at 30% on the enhanced compensation. Interest, so this should be solatium at 30% only on the market value, not on the enhanced compensation. So this is incorrect. And interest at the rate of 12% per annum on the enhanced compensation. So here what is wrong is it should have been 9%, not 12%. But the court is correct in recording that it should be on the enhanced compensation. Now kindly see at serial number 7.
Solatium.
So the court calculates the solatium at 30% on the enhanced award, that is 15,61,000, not on the market value.
Yeah. Yes.
Similarly, at the next page, page 330, at serial number 8, Lordship will find it is 12% interest per annum on the enhanced compensation, which is 15,61,000. It brings that total to 1,87,332.
With effect from?
With effect from 13/9/2001 to 12/9/2002. This is for that first period. Under section 28, for that first period. So, because of this incorrect computation, the entitlement of the claimants has considerably gone up.
Enhanced plus ratio rate 30%. Yes.
And, my lords, while I'm on the decree, there is...
Now what I've done, they've minus that 255 they got
later, after computing the interest, which is not permissible, my lords. They have applied interest and solatium to it.
They applied it, but then yes, for the... Yes.
They should have deducted it first. It has already been paid in 2001. They have applied the interest for the entire period of 17 years.
Yes.
And, my lords, this is beyond the judgment. The judgment said enhanced compensation.
Yes.
Now, while I'm on the decree, my lords, there's something else I noticed. Kindly have page 331. So, we've dealt with the first period. That is at 9%. It should have been 9. The court has awarded 12. Now, this is a subsequent period of 15%. Now, the date of this judgment is 17/3/2020 and decree has been drawn up with the same date. But kindly see the future interest. Now, additionally, interest at the rate of 15% per annum on the net compensation with effect from 13/9/2002 till 12/12/21. Court has granted interest for a future date.
How is it arrived at?
I'm not sure what is so special about this date. Why this date?
It's 21 or 20.
It says 12/12/20. Even if it is 2020, there is no reason why it be 12th of December. There is no reason at all. Because the date of the judgment is 17th of March 2020. The court could at best have calculated interest till that date. Now let's even assume that we want to look into the date when they had filed that application for correction of the judgment. That was disposed of on 15th of April 21. Lordships will recall, as I had said earlier, pointing out that there was a mistake with the grant of solatium. They had filed an application under 152. That was disposed of by the court on 15/4/21. So then the question is, why would future interest be granted till 12/12/21? These are all apparent mistakes.
How can it be reconciled? How can it be explained?
That would be for the respondents to explain. I'm not sure how this date has come through. 12/12/21.
It makes no sense.
For the purpose of calculation of the interest, they have to give a date in. That up to this date interest is counted.
Why? 21.
21 because this decree were prepared on that day. Physically. Otherwise the decree bears the same date as that of the judgment. But normally this decree takes a lot of time. And therefore, therefore, Lordship...
For the time allowed for drawing of the decree, that means you have paid future interest.
A future interest.
Okay.
I've gone through Order 20, it's not supported. Because the date of the decree must be the same as the date of the judgment. So that is rightly what has been done here.
Post-award?
No, that will be collected at the time of execution. At the time of execution, the execution application will indicate that. And the executing court will do that. It is not for the court to do this. Because the date of the decree here is 17th of March 2020. How could the court grant future interest? And the records don't show that the physical decree was actually drawn up on this particular date.
Well, that is what I said. How do you reconcile it?
So there was another argument which was made by my learned senior that while granting compensation, while applying interest under Section 28, the interest should be on the entire compensation, which is under Section 23. We are not disputing that position, my lords. That is supported by all these judgments. We are not disputing that. That was never our case. We have never argued that the application of interest under Section 28 should only be limited to the market value. That was never our case. We concede to the fact that that's a position of law. We can't quarrel with that. It is to be granted on the entire compensation, which includes all the 6 factors as well as the solatium. That is not our case. My learned senior argued that it is our case that application of interest is only limited to the market value. That is not our case. We have never argued that. Then the other part, my lords, was that the application of interest for the subsequent period at 15%, while that is discretionary, the court should have excluded certain periods which were spent during the pandemic, and number 2, when we were at least proceeding with the matter bona fide. Now, kindly see, this judgment was passed on 17/3/2020. The court has applied future interest without even looking at that aspect of the pandemic. Number 2, that written arguments were filed by the parties on 6/3/2017. The case was fixed for judgment on 25/5/2017, but could not be delivered. Thereafter, it was reheard by other judges, and finally, it was reserved for judgment on 16/12/2019, and judgment was rendered on 17/3/2020. So, at least for that period, when we were at least pursuing this matter bona fide, that application of interest should have been excluded. Furthermore, it is not anybody's case that the entire period of 17 years, the delay was attributable to the state or to the collector. So the court could have looked into the matter. That has a huge financial implication. So I had referred to a judgment of the Honorable Supreme Court, 2011.
What's the entire amount, Mr. Jindal, that was awarded for all the claimants?
3 point...
entire amount?
Around 6 plus.
6
yeah.
plus. 6 point something crores.
Yes, for all these people.
For all these people?
For all these people.
All total. So I had referred to a judgment on the discretionary powers of the court, how it is to be exercised, 2011 4 SEC 363.
Yes. 2011
4 SEC 363. Lanka Venkateshwarlu. At page 373, para 29. Para 29. Well, as the 5th line from the bottom of para 29, it begins with all discretionary powers.
Yes.
All discretionary powers, especially judicial powers, have to be exercised with reasonable bounds known to man. The discretion has to be exercised in a systematic manner, informed by reason. Whims or fancies, prejudices or predilections cannot and should not form the basis of exercising discretionary powers. So while granting 15%, court should have at least assigned some form of reasoning in this matter. So this would conclude the issue on the merits. The next part, my lords, I would pray for time till tomorrow. That relates to the issue of the cross objections and the individual appeals that have been filed by my learned senior. There, I think broadly what the grounds are. One is that the collector was duty bound to lead evidence, and because of the default of the collector, the court has to accept the rates which have been brought on record by the claimants. Number 2, that whatever documents have been placed on record, especially and particularly Exhibit 4, 5 and 6, which are the unregistered sale deeds, because there was no challenge to those documents at the time of bringing it on record, therefore the state has lost a right to challenge it. That is the second. And number 3, that even if unregistered documents are inadmissible evidence, they can be looked into for collateral purpose. Those are the 3 broad issues, my lord. I'll cover it tomorrow.
Go on. This is for the hearing tomorrow. How long will be reply, Mr. Jindal?
Lordship.
2 days reply. Very interesting point, especially on that point of
Your Lordship
the
will
Section
only-
28 interest
Lordship will
and
appreciate-
Section 1A. Yeah.
Lordship will appreciate one thing. My learned friend has brought so many things before your Lordship. Had they taken little pain before the collector, before the court below?
We can't go there now. We look
No,
forward.
please,
It's over. It's water
No,
under the
no.
bridge.
Where is their case before the trial court?
Exactly, it was water under the
Nothing
bridge.
is
But
there.
but now we're going on points of law only. What is argued with regarding to the maximum compensation, with regard to solution, with regard to interest. That's only interpretation of Section 23, interpretation of Section 28, Section 23 1A. So we have just to match whether what was done by the special judicial officer that was as per law. That's all. So from what I understand, I might be wrong. What I understand that he's arguing as per law that okay, fine, this is what the law prescribes, but the facts do not follow that. That's all.
And in addition, my lords, the judgment says something. The decree does not agree with the judgment. Decree has gone beyond what has been prescribed in the judgment.
Yes.
22.
Obliged, my lord.
22.
Finish mediation.
Mediation, Your Lordship, today it is fixed for. Just I got information from that it could not be settled.
Where's the report?
I do not have anything, Your Lordship. Only today morning I called up the High Court mediation.
Yes. Yes. Flag A. That one. A report dated 26 June 2024 has been furnished, which indicates that mediation proceedings before the nominated mediator have failed. We'll close the matter next date.
Yes, Your Lordship.
Just a matter for 1 week, yes.
Yes.
Because the order is already there.
Yes, Your
8th of May order is already there. 8th of May the courts already observed that the entire procedure, right from village court up to, was all wrong. You have not been allowed to tender evidence even once. None of the parties also. So whether applicant current customary law, what should be done in a proper manner?
Yes, Your Lordship.
Okay. You will have no role to play then after this. Yes.
Much of
24.
Madam Taiba, fine.
24 across item till item 28, my lord. 24, yes. Mr. Chanda would be appearing.
Mr.
I'm appearing.
Yes, and Mr. Chanda. Yes.
Let Mr. Tata submit, my lord. They have got 3 cases.
My lord, we have actually submitted a written submission. It's already on record. The litigant case in this case is...
It's not on record. Where's the record? Where's the written submission?
Your Lordship, I'm submitting now, Your Lordship.
Yes?
I'm submitting now, Your Lordship.
Well, submitted now only. You've given copy to you.
No, Lordship, we haven't received.
What's that sound? The thunder.
We have received it just now from the petitioner.
My lord, basically the case was that there's a division bench judgment which actually has decided the issue against us. So we are in a way, my lord, our hands are tied by that judgment.
You see, you have looked at written submissions, you reply, we'll close it next date.
But the matter has been decided by Supreme Court, my lord.
What happened?
Same matter, my lord. Matter decided by single bench of this Honorable Court decided in favor of petitioner, my lord. We filed an appeal, division bench decision is in the favor of department. SLP also dismissed, my lord. And these are squarely covered with those cases, my lord.
You've seen the Supreme Court
trying
judgment?
to find out some
Yes, my
point
lord,
here
yes.
to trying to distinguish, my lord. In my humble submission, nothing is left in these matters.
The only distinction that we are trying to draw is that, my lord, firstly, when this people were remastered, my lord, from the clerical trade to ZT trade, my lord, that was not done on the basis of any recruitment rule. Secondly, my lord, at that point of time, even they were, when remastered, my lord, there was no disparity in pay scale. So they enjoyed the same pay scale and they were therefore, my lord, not agreed. Till in 2018, when the clerical trades, my lord, the scale got revised. And thirdly, my lord, FR 22 should have been followed in case of also change of trade, as far as in determination of their scales is concerned, my lord. These 3 points were not urged before the revision bans. Therefore, my lord, were never considered, my lord.
I used to examine it.
My lord.
Written submissions are submitted by the petitioners. We didn't ask for written submissions.
No.
Now, why did you file written submissions?
My lord, just for some clarity, additional clarity, my lord.
You didn't leave the court. This court doesn't like written submissions. Yes. Written submissions just lengthens the process. Anyway, you examine. We'll have it after because take down written submissions have been filed by the petitioners for consideration by this court. Well, it's for this court. Next paragraph, Dr. Mosika submits that these batch of cases are covered by the judgment of the division bench passed in WA 18 of 2019 and also by order dated, which Supreme Court order dated 28/8/2023 passed by the Supreme Court on appeal therefrom. He submits it as the case stand covered. They deserve no further consideration. Notwithstanding next paragraph. Notwithstanding submission of DSGI, releases matter after 1 week. I'll go to examine this. But if they've been severed since when?
Some 20 years.
20 years ago.
My lord.
Then what right continues now?
The disparity in pay, my lord, started in 2018 when this clerical trade, my lord, because of judgment. Some other judgments, we got a different pay.
They were general duty, my lord. And for remuneration to clerical cadre, there was an order, my lord. To those who want to apply, they can apply to become clerical cadre, my lord. Subject to passing of certain.
He failed the exam.
He remustered, my lord. He failed in exam, so he was reverted back to his. Now what happened, my lord? Clerical cadre came before this honorable court, my lord, and they were given retrospective service benefits in pay and all that. Now they are claiming that benefit for the period they served in clerical cadre for maybe 6 months or 1 year, my lord. Now the division bench.
Well, we'll see it. Yes, just see what division bench is.
31.
Lord, I pray, my lord, this matter may kindly come up after 2 weeks, my lord.
And of the board?
2 weeks, my lord.
Why?
Today, my lord, it's little difficult.
Today is raining too heavily. As the Ms. Sincon submits that raining too heavily, we'll record that.
No, my lord.
Yes. Yes, on the prayer, Ms. Sincon lists the matter after 2 weeks. Yes.
Obliged.
Much obliged.
39.
May I please, Your Lordship?
Yes.
On the last occasion, Lordship has perused one judgment I have submitted. My Lord, my case only stand on humanitarian ground, my Lord. Otherwise, on law, I have no case, my Lord. Because the scheme
has already
been abolished, my Lord, by the recommendation of 4th Meghalaya Pay Commission. But, my Lord, in the judgment, my Lord has passed, in that judgment, the 5th Meghalaya Pay Commission again recommended for the inclusion of the scheme, my Lord, in exceptional circumstances, my Lord. I have submitted to my Lord. Yes, Marvelin. I am thinking also, no? Same, yes, Marvelin. My lord, I was appointed in the year 2014, my lord.
Now, Mr. Hassan.
Yes, my lord.
You were you accommodated as
assistant teacher, my lord.
Then what happened after that?
Till December 2023, I was working there. Thereafter, my service has been discontinued.
No, when he started working, he was killed by?
GNLA, my lord.
Okay.
My father was killed by a GNLA while my father was on duty as the headmaster of government Haldibari Government LP School, my lord, under West Garo Hills. Then my mother had filed a representation before the Deputy Commissioner for immediate assistance from the Deputy Commissioner. Then Deputy Commissioner issued a letter to the Director of School Education with a request to appoint the petitioner on compassionate and humanitarian ground, my lord. Thereafter, the Deputy Commissioner issued another letter, my lord, on the same month, 27th 6, 2014, to the Director of School. 27/6/2014, my lord. Annexing all the documents submitted by the petitioner to the Deputy Commissioner. He has forwarded all the documents, academic documents of the petitioner to the Director of School, my lord. Thereafter, my lord, DI, my lord, Dadangiri, SDSEO, has also forwarded one letter to the district school, to the Director of School, requesting the director to appoint the petitioner on humanitarian and compassionate ground. Because
is she qualified?
My lord, while he was appointed, he was qualified, my lord. He was 12th pass. That time there is not not required of DLED, as well as there is no MTET that time. I was qualified.
Now you don't have the requirement.
Now I have DLED, my lord, but unfortunately in the last exam I have failed, my lord. MTET, my lord. In the last exam
DLED, you teach primary school only?
Yes, primary school.
Then put her in a primary school.
Yes, I was working in the primary school, my lord.
This MTET, Your Lordship, has become mandatory since 2010, Your Lordship.
Get some other post.
In 2014, he was appointed. So that time also it was mandatory.
14, when did your father?
He was appointed in August 2014,
August
Your Lordship.
2014, my lord. But MTET implemented in our state.
Where did the incident happen when your father was shot?
Yes, in 2014 only, Your Lordship.
In 2014, my lord, the incident happened, my lord. My lord, at page 7 of my petition, para 3, my lord.
See, if you're not qualified, it's not difficult. We cannot,
my lord.
Page 14.
My lord, no, page 7, my lord. Page 7 of my petition, para 3, my lord. I have mentioned, my lord.
Yes.
May I read, my lord?
Yes.
The petitioner
There's
states.
no need to.
Yes, my lord. Yes. Annex the death certificate also, my lord. My lord, while I was appointed, MTET was not necessary, my lord.
No, it doesn't matter.
MTET.
But the thing is that even upon at that time, all these candidates who were appointed who didn't have rigorous qualification, they were given some time to qualify themselves.
Yes, my lord.
As per this NCTE norms, which we cannot wish away.
Correct, my lord. I agree. Then, my lord, let my service may be continued and last chance may be given. If I am not qualified, then my service may be terminated, my lord.
No, give her some other post or him some
any
other
post, my lord. No problem.
Or
my lord, any other post, I am agree because otherwise, my lord, I have.
But I'll have to seek instructions on that because somebody else has already been appointed in his post, Your Lordship, who is a qualified person.
Now you're out of the
and
job.
who has come through the regular selection process.
I have a sister, my lord. She is studying.
The petitioner by the instant petition is seeking appointment on compassionate and humanitarian grounds. Inasmuch as your father,
yes,
the father, inasmuch as his father, while on duty, as headmaster.
Yes, my lord, headmaster.
Which school is this?
Haldibari.
Haldibari Government LP School.
Haldibari Government LP School.
Under West
Garo Hills was shot dead by extremists. Stop. Thereafter, it appears that the petitioner, on the representation of his mother,
Yes, my lord.
was accommodated.
Yes,
on contractual basis.
On a contractual basis.
No, my lord, we just request the
was
deputy
accommodated
commissioner.
as what?
As my lord.
As
Where's that?
My lord, yes, my lord. Annexure 3, my lord.
Was accommodated temporarily.
Yes, my lord. Annexure 3, my lord. Type copy at
Where's
page
what?
23, my lord.
Annexure 3, this is a representation.
My lord, yes, my lord, representation.
Where's the appointment?
My lord, appointment, yes, my lord.
He was appointed in August, Your Lordship, at page 31.
Yes, my lord. At page 31, yes, my lord. Appointment
Where's
of
that?
Government LP, at page 31, my lord.
Yes, Thomno. As where's that?
Teacher on contract basis.
Where's that written teacher contract basis?
My lord,
This is
at
at page
page
31, the
31.
subject, Your Lordship, at this in the subject. And the
Yes,
second, last
was
paragraph.
accommodated on a contractual basis
For
as
59 days
assistant-
initially, Your Lordship.
as assistant teacher for a period of 59 days. Stop. On 21st August 2014. However, it is submitted by Mr. S.K. Hassan that the said arrangement has since been discontinued due to the fact that
He did not have the necessary qualification.
and the fact that the petitioner did not possess
My lord, no reason has been cited, simply discontinued, my lord.
has been discontinued.
Yes, my lord.
Which he submits ostensibly is because he does not possess the MTET qualification. Stop. Next paragraph, it is further submitted that and prayed that it was submitted that the petitioner is well aware that there is no compassionate scheme that is subsisting presently, but that and in this regard has placed an earlier judgment of this court dated 24/3/2023, passed in WPC number 443/2020, where this court had observed at para 7 as follows.
Yes, ma'am.
And had granted relief to the petitioner, though it was observed that, though it was given therein that the same should not serve as precedent.
And in this case, Your Lordship, if I may interrupt, this person had the qualification.
It was not served as a precedent, doesn't matter. Yes, the next paragraph. He therefore prays that similar consideration be given and the respondent be directed to consider the petitioner to be appointed against suitable posts considering his qualifications. Next paragraph, Ms. T. Yangi, learned EAG with so-and-so, submits that the fact that it remains the fact that the petitioner is not qualified is undisputed, and his continuance in the post from 2014 was purely on humanitarian grounds. Stop. She further submits that she will be allowed to obtain instructions
For appointment to any other
yes, for
post.
if whether the petition can accommodate to
Because
any
that
other
position
suitable
which he
post,
was holding has
any
already
other
been filled
suitable
up.
post considering the qualifications that the petitioner possesses. Yes, we list after.
A month, Your Lordship.
Just
let me-
after 4 weeks, yes.
Hello, oblige, madam.
Yes, Mr. Khan. Tomorrow I have problem.
Any cases are prayed for tomorrow. If Lordship will kindly have it on Thursday. Tomorrow I have some difficulty. There are other hearing matters. I've
Before
taken
this
my
court?
senior's consent.
Before this court, the other hearing matters.
Here as well as the other courts, my lord. Would Thursday be convenient, my lord?
Thursday would because Thursday you see there's a slight other matters of Thursday also. No.
Or Friday, if that is convenient. I'll be brief.
Yeah, Friday. No, Friday doesn't matter because it won't end here also. Mr. Jindal is not going to let
Yes,
you
yes,
get off
right.
easy.
Yes.
To your submission, especially in the section 28, it's going to take 2 days. Yes.
Yes, I understand. So Friday then, my lord.
Friday is.
Highly obliged.
Friday is 5th. Right.